Imagine this. You come home after a long day, drop your keys on the counter, and walk into your bedroom. Your landlord is standing there. He's not there for an emergency. No broken pipe, no fire alarm. He just wanted to check on the place. You didn't get a text. You didn't get a call. There was no note on your door. Everything in your home feels exactly the same, except for the fact that someone just walked into your private space without your permission, and you're not sure if that's even legal. That scenario is hypothetical, but the question underneath it is real. Millions of renters across the United States wonder the same thing. Can a landlord walk in whenever they want? Do they have to call first? Is there a law that protects you? Or are you just supposed to deal with it because you pay rent and they own the building? The short answer is that in most states, your landlord cannot enter your home whenever they feel like it. Not with the key they gave you for emergencies. Not just a check. And not without telling you first. But how much protection you have depends heavily on where you live, what your lease says, and the specific circumstances. By the end of this video, you'll understand what generally applies, the mistakes people often make, and why this topic matters in everyday situations, not just in dramatic ones. Let's start with the most important idea, the one that everything else hangs on. When you sign a lease and move in, you don't just rent the walls and the floor, you rent something that the law calls quiet enjoyment or exclusive possession. That phrase sounds formal, but the concept is simple. The space inside your rented home is treated like yours for the duration of the lease. Your landlord does not have the right to walk through it like it's their own living room. They're not a guest. They're not a house inspector with unlimited hours. They have a defined right of entry, and that right is limited by law in most states and by the lease terms in every state. So the next natural question is, when can they actually come in? In the majority of states with written landlord entry rules, there are only a handful of situations that allow a landlord to cross the threshold. The first is emergencies. If something is actively going wrong, a burst pipe, an electrical fire, a gas leak, a serious safety threat, the landlord doesn't need to wait for permission or schedule a time. They can enter to protect the property or to protect you. The second is repairs and maintenance that you have requested or that are genuinely necessary. The third is inspections that are reasonable in scope and frequency. The fourth is showing the unit to prospective tenants, buyers, or contractors. In some states, landlords can also enter if they have a reasonable belief that the tenant has abandoned the property, or if a court has ordered access. Outside these categories, the entry is typically not allowed without your consent. That brings us to the word that almost every state uses, reasonable notice. You'll hear this phrase constantly when researching tenant rights, because it's the legal thread that connects a landlord's right to enter with a tenant's right to privacy. Reasonable notice generally means giving you advance warning before coming over. The most common standard across the country is 24 hours written notice, but the actual number varies by state. California, for example, treats 24 hours as the standard for written notice. Florida requires reasonable notice, which is commonly interpreted as around 12 hours. Massachusetts generally requires 48 hours notice for repairs. New York does not have a single fixed number, but the standard is reasonable notice, which in practice often means 24 hours. Other states, like Minnesota, set 24 hours in statute, but allow tenants to agree in writing to a shorter window. So the truthful answer is that there's no single federal rule that applies everywhere, and the rule that applies to you depends on your state and your lease. Here's where many renters get confused, and it's a mistake worth understanding before it ever happens to you. Some states do not have a specific landlord entry statute at all. Georgia is a frequently cited example. In those states, the rights and obligations around entry are shaped mostly by what the lease says, what courts call custom and practice, and general principles of privacy. The practical effect is that if your lease is silent on entry and your state is silent on entry, there's a gray area that's not always comfortable to live in. This is why renters in unregulated states are often better off negotiating lease language that creates clear rules around notice, time of day, and purpose. A clause that says, landlord may enter with 24 hours written notice for repairs, inspections, and showings during normal business hours is far more protective than silence. Now let's talk about what makes an entry actually unlawful, because not every unwanted entry is treated the same way under the law. An unlawful entry generally requires a few ingredients. The landlord enters without proper notice, or enters without one of the legitimate reasons we just covered, or enters in a way that's abusive or harassing. Walking in while you're at work to look around without telling you is not the same legally as coming in to fix a leaking sink on short notice. The seriousness of the violation depends on intent, frequency, and impact. A single sloppy mistake might be a lease violation. Repeated, unannounced entries that leave you feeling watched or controlled can rise to the level of harassment. And harassment is something courts take much more seriously. Here's where many people overestimate their protection. And this is the kind of misunderstanding that can cause real problems. Your state having a written 24-hour rule does not mean your landlord is criminally guilty every time they walk in without sending a formal notice. Civil remedies, not criminal ones, are usually the path for tenants. If your landlord enters improperly, you typically don't get to call the police and have them arrested on the spot. You get to document what happened, give written notice of the violation, request that it stop, and if it doesn't, pursue the remedies your state provides. Those remedies vary. Some states allow you to break the lease and walk away. Some allow you to sue for actual damages. Some allow statutory damages, meaning a fixed amount per violation. A few states treat repeated unlawful entry as a form of constructive eviction, which can let you leave without owing further rent. The point is that your protection is real, but it usually works through paperwork, evidence, and possibly small claims or housing court, not through emergency confrontation. Let's slow down on notice, because this is where landlords and tenants talk past each other most often. Written notice usually means something delivered to you, like a note under the door, an email to the address you provided, a text message if your lease allows it, or a formal letter. The notice should include the date, the approximate time, and the purpose. A vague, "I'll be by sometime this week" is not the same as "I will enter at 10 a.m. on Thursday to replace the kitchen faucet." Courts tend to look at whether the notice gave you a fair chance to be present or to secure your belongings, and whether the stated reason was legitimate. If your landlord writes "general inspection once a month" for no real reason, that's a pattern that can start to look less like reasonable maintenance and more like an intrusion. Most states also expect entries to happen during normal hours, often described as business hours, typically 8 a.m. to 5 p.m. on weekdays. An entry at 11 p.m. to check on a sink is going to look very different to a judge than one at 10 a.m. on a Tuesday. A practical example helps here. Suppose you call your landlord about a broken dishwasher. They come the next day without sending a written notice, but they knock, you answer the door, and you let them in. Was that lawful? Probably yes, because you requested the repair and you consented at the time. Now change the facts. The dishwasher isn't broken. Your landlord comes by because they're thinking about selling the building, and they walk into your apartment to show a contractor the layout. They didn't send you a notice. They just let themselves in with the master key. That second scenario looks very different. You didn't request it. You weren't given a chance to be present. The purpose wasn't one you agreed to. That's the kind of entry that tenants can successfully challenge, and it's the kind of entry that experienced landlords avoid because they know it can become a legal headache. The word abandoned is another one worth pausing on because landlords sometimes misuse it as a shortcut to entering. Abandonment usually has a legal definition in your state. It typically means the tenant has moved out, removed their belongings, stopped paying rent, and indicated by clear behavior that they don't intend to return. If those conditions are met, the landlord may be able to enter to secure the property and prepare it for re-renting. If those conditions are not met, but the landlord is just suspicious because you didn't answer call for 2 days, that is not abandonment. People take trips. People work long shifts. People ignore phone calls from their landlords. None of those things alone give the landlord the right to walk in. What about lockouts? If you've ever been locked out by a landlord in a dispute, that's actually a separate issue from unlawful entry, and the rules around it are usually stricter. In most states, landlords cannot change the locks, remove doors, shut off utilities, or otherwise force you out without going through the formal eviction process. Doing so can be treated as an illegal lockout, and in many jurisdictions, it's punishable as a self-help eviction. So if your landlord ever physically blocks you from your own home, that's not just a privacy violation, that's potentially a serious legal violation, and the remedies tend to be much stronger because it's harder to defend and easier to prove. Now let's talk about the lease, because even in states with strong entry laws, the lease can shift the rules. Many leases include a clause that says the landlord can enter with reasonable notice for a list of permitted purposes. Some leases go further and give the landlord broader access rights. Some leases are silent entirely. In states with statutes, the statute usually sets a floor. Your lease cannot take away rights that state law gives you, but your lease can give you more rights than the minimum, and if it does, the lease controls. So the more protective rule always wins. If your state requires 24 hours and your lease requires 48, your landlord has to give you 48. If your state says reasonable notice and your lease specifies 24 hours in writing, the lease gives you a clearer standard that's easier to enforce. One more area worth understanding, because it comes up often: showings near the end of a lease. If you're planning to move out and your landlord wants to show the unit to prospective tenants, that's a permitted purpose in most states. And it's the time when many tenants feel the most intruded upon, because the entries can be frequent. The law generally recognizes that landlords need to market the unit, but courts also recognize that you still have a right to quiet enjoyment. The typical standard is reasonable notice for each showing, a time that's not disruptive, and a frequency that's reasonable for the situation. Multiple showings a day for 2 straight weeks without coordination is going to look different from one showing per week, scheduled in advance, with your cooperation. If you're in this situation, the practical move is to ask for written notice for each showing, respond in good faith, and document anything that feels excessive. If you're in a situation where your landlord is crossing lines, here's a sensible, step-by-step way to respond without escalating the conflict and without losing your rights. Step 1 is documentation. Keep a log, every entry, every notice received or not received, every conversation. Texts and emails count as evidence. Step 2 is a written request. If the entry was improper, send a polite, factual written message describing what happened, what the lease and your state law require, and ask that it not happen again. Email is usually best because it creates a paper trail. Step 3 is escalation. If the behavior continues, send a second notice, this time referencing the first. Many housing attorneys recommend sending it by a method that proves delivery. Step 4 is formal remedies. These can include contacting your local housing authority, contacting a tenants' rights organization, filing a complaint if your state has one, or pursuing a claim in court for damages or for the right to break the lease without penalty in states that allow it. Step 5, in the rare serious cases involving harassment or repeated unannounced entries, is consulting a licensed attorney in your state. If the cost of a consultation is a barrier, many legal aid organizations handle tenant issues for free or at low cost, especially for low-income renters. A few things people often get wrong and worth correcting in plain language. First, silence does not mean consent. You can give verbal permission in the moment, but if your landlord doesn't ask, your silence is not the same as consent. Second, the fact that the landlord entered with your permission once doesn't mean they can keep doing it without asking. Each individual entry typically requires fresh notice or fresh consent. Third, locks changed for your protection, like after you lose your keys, do not give the landlord a permanent right to enter. Rekeying the locks is a safety measure, not a waiver of your privacy rights. Fourth, even emergencies are limited. A landlord cannot use emergency as a general excuse to enter whenever they want. A legitimate emergency is something genuinely urgent, not a pretext. There is one more practical point that doesn't always show up in summaries. If your landlord gives proper notice and you refuse entry without a reasonable basis, that refusal can itself become a problem. Tenants generally cannot block legitimate entries for repairs, inspections, or showings if the landlord is following the rules. If you refuse, the landlord in many states can document the refusal and, in serious cases, treat it as a lease violation. The right to privacy is real, and abuse by landlords is real, but refusing all reasonable access is its own kind of problem. The healthy middle ground is to insist on proper notice, cooperate with legitimate entries, and protect yourself from anything that crosses the line. So, if you only remember a handful of things from this video, let them be these. In most states, your landlord needs to give reasonable notice before entering, and 24 hours is the most common standard, but the exact rule depends on your state and your lease. Entry is generally allowed for emergencies, requested repairs, reasonable inspections, and showings within reasonable hours, and only with the notice your state requires. Unannounced entries for vague or personal reasons are usually unlawful, and the remedies are typically civil, not criminal, which means documentation matters more than confrontation. Your lease can give you more rights than the minimum, but it usually cannot take rights away that state law provides. And if you ever feel that the line is being crossed, you have options that begin with writing and can end with formal action, and you don't have to handle any of it alone. The reason this matters isn't dramatic. It's not about a single villain landlord. It's about the quiet feeling of knowing your home is actually your home, and that the person holding the master key has the same legal duties as anyone else with a key. Most landlords are reasonable. They send notice, they knock, they wait for you to open the door if you're home, and they move on. But knowing your rights means that if the person holding the key steps over the line, you're not caught off guard. You're ready, and that makes all the difference.